Good morning or good afternoon, wherever you may be dialing in from. Hope everyone's doing well. Welcome to another session in our Fieldfisher Silicon Valley webinar series. I'm Megan Ward, a privacy advisor here in the team, and I'm joined today by Mark Webber, US Managing Partner, and Paul Lanois, a director in our team. Today's topic is learning from data, whether that's artificial intelligence, machine learning, or another form of algorithmic processing. We're going to be looking at what are the legal hurdles faced when learning from data, personal data or otherwise. What should you consider if a vendor wants to learn from your data? And how can you implement good practices now to plan for future regulation and scrutiny? And it's a good time to be planning ahead and looking at what practices you can implement now to shape development of AI systems. We're seeing increased investment in AI at European level, country level, and at company level as well. And recent publications demonstrate a move towards tighter regulation around AI, which seek to balance fostering this development and increased investment with the associated risks and its responsible use. And some of those to name but a few of the European Commission's white paper on AI, and there's been some guidance from the UK regulator, the ICO2. And even just within the last week, you may have seen in the news that the UK regulator and Australian regulator announced a joint investigation into how Clearview trains its facial recognition models and into its data scraping practices. So it's definitely a talking point at the moment. So Mark and Paul, I'd like to kick us off with what sorts of data sets might companies want to learn from?
Sure. Thanks, Megan. So when we are discussing artificial intelligence, I guess it's hard not to talk about privacy laws at the same time, right? So we have at the EU level, we have the GDPR, and in the US, there is, for example, the California Consumer Privacy Act, the CCPA, which went into effect earlier this year in January, and which is now being enforced by the California Attorney General. And it's probably the most complete data privacy legislation passed in the United States so far. And the CCPA is similar in many ways to the GDPR. In a nutshell, both the GDPR and the CCPA provide that individuals have certain rights in relation to their personal information, such as the right of access, the right of modification, right of deletion of their information. Both legislations impose disclosure requirements. In particular, in California, the CCPA provides limitations on the sale of personal information, requiring, for example, that businesses include a "do not sell my personal information" link on their homepage. But let's examine how this legislation actually apply in the context of AI. And I guess the starting point would be personal information. What is personal information? And under the CCPA, for example, personal information means information that identifies, relates to, describes, is reasonably capable of being associated with, directly or indirectly, with a particular consumer or a household. And I'm not going to go through the entire definition of personal information, but then in the text of the CCPA, there are different categories of what constitute personal information under the CCPA. We have identifiers, biometric information, commercial information, and so forth. And what is really interesting here in the context of AI is that one of the categories of personal information which exists under the CCPA is the category which is called inferences drawn from any of the information identified to create a profile about a consumer, reflecting the consumer's preferences, characteristics, psychological trends, predispositions, behavior, attitudes, intelligence, abilities, and aptitudes. And the CCPA, because it has this category which is called inferences based on data, it means that whenever an organization creates a data profile for a consumer based on connecting a group of data points, that profile will also need to be covered by the different privacy rights which are provided under the CCPA. Now, some of you may say, well, the CCPA also provides that personal information does not include publicly available information, and then you may say, aha, well, this possibly means that we can collect as much information as we want from social media, search engines, and so forth, and because the information is publicly available, we can it's not covered under the definition of personal information under the CCPA. And while it is true that the CCPA says that personal information does not include publicly available information, it does later on add an important qualification. It says that publicly available means information that is lawfully made available from federal, state, or local government records. And therefore, the CCPA is saying that, well, it doesn't, the exception under publicly available information would not cover anything else. So just because the information is available on social media, search engines, and so forth, doesn't mean that it would be excluded from the definition of personal information under the CCPA. And personal information as well does not include consumer information that is de-identified or aggregate consumer information. So under both the GDPR and the CCPA, we have therefore a common set of principles. One of the key takeaway, I guess, from the enactment of both the GDPR and the CCPA is that the previous anything goes data free for all, which used to exist before, is now no longer permitted. It's essential now to have good data management and governance. It's no longer a nice to have feature, it's actually a requirement. And this is not necessarily a bad thing. As the saying goes, well, garbage in, garbage out. If you want to produce reliable models and data sets, well, you also need to have input data of high quality. It doesn't matter how good your AI models are. If the input data that you use to build and to implement them are bad, then you would have bad data sets, which would result. Now, the reality is that you need to also understand the how, the where, the when, and the from whom the data is captured, because any of those different aspects can also be a source of error. For example, no matter how up to date the information that you capture is, well, it's always going to just be capturing a snapshot in time. So knowing when, how recently the data was collected and how the data was collected is therefore critical. The dates would determine how to implement and how to understand the current state of affairs. For example, if you have data which is 5 years old, well, it's very likely to be less representative of the present data that is only 5 minutes old, all things being equal. And the frequency of the data collection is also important because it has an impact on the types of models that can later be used and how those models can be calibrated. The second critical part, I would say, is understanding how the data was collected, because it's not always possible to have a flawless collection mechanism, because let's take an example. Let's say you have data collected and you want to understand the purchase behavior from customers. well, if you collect such data via a survey, it's very likely to be different from data collected at the point of sale. And the reason for that is that, well, it's very likely that people would be saying that they did something which may not necessarily be the same as what they would actually do. And therefore, how you handle the data in both situations to address how you collected the data is going to be very important. So now that since now we have this, we understand what personal data is, how it's being collected, and so forth. This means that the different privacy rights which exist under the GDPR and the CCPA would apply to the information, and there are various rights under both legislations. For example, both legislations have both legislation grants to individuals the right to be informed about the collection and use of their personal data. And this is a key transparency requirement under both the GDPR and the CCPA. And in this respect, I would say that California actually goes a little bit further than what we currently have in the EU, because there is a law in California, California SB 1001, which is also known as the Bolstering Online Transparency Act, or BOT Act, which imposes a transparency requirement. This law makes it unlawful for any person to use a bot to communicate or interact with another person in California online with the intent to mislead the other person about its artificial identity. So this means that under this piece of legislation, you have to disclose to customers that you are using a bot, and you have to disclose it in a manner that is clear, conspicuous, and reasonably designed to inform persons with whom the bot communicates or interacts. And we have as well rules and guidelines issued by the Federal Trade Commission, the FTC, in relation to online disclosures. And this means that if you have statements like I am not a person, in order to make such a disclosure requirement, well, that would not be sufficient. You need to have clear affirmative statements.
Thanks.
And then just very quickly, other privacy rights include the right to be the right of deletion, the right of opting out, and the right of access.
Thanks, Paul. So we've taken a quick look at where the data might be coming from. Mark, so if we could talk a bit about applying AI to someone else's data, what are the things we need to think about there?
Yeah, we could. I mean, yeah, let's sort of talk about this and you know, where we're coming from this. One of the reasons for putting on this particular webinar was one, we're spending an awful lot of time with clients who are beginning to develop their AI and learning models, and a lot of that is, in the eyes of the privacy advisor or the internal teams, is often black box. They've got data, they've got AI, but they're not quite sure where it's coming from or what they're doing with it. As we'll talk about it a little bit later on, both in Europe with some proposed rules and existing rules under the GDPR, and now in California and elsewhere, there's becoming a much heavier focus on documenting compliance. And if you're going to document your compliance, you need to be able to understand what data is involved, as Paul's beginning to say, understand what rights are involved, otherwise you can't inform. You need to be able to justify the processing that's taking place, making sure that you're testing the quality of data sets, preventing bias and discrimination, and maybe the statistical accuracy of those sets. And maybe even rebalancing the way you train those models to ensure that you can eliminate bias or ensure there's no discrimination. Also, you need to understand the overall data and the purposes for which that data is being used within the model to explain the logic. And we'll talk a little bit about why you might be able to do that. But one of the interesting things about all of this, and why are we talking about training data? Well, the data's got to come from somewhere. And Paul's given some examples that it could be publicly available, walled gardens. You could even have synthetic data that you're, buying in from a third party, which is artificial and sufficient to train. But in many circumstances, and particularly many circumstances that we're working in, we're working with SaaS or cloud vendors who are in themselves vendors of core services. It may be that they have a CRM system, or it may be they have a chatbot, or it may be that they're providing some kind of analytical service in relation to customer data sets. Now, those SaaS providers, generally speaking, are vendors. They're data processors. They're signing data processing agreements, the DPAs, signing up to becoming compliant with Article 28 under the GDPR. And really the primary purpose of using that data is providing and securing the product or service, perhaps providing insights and analytics to the customer, and building on the uses of that customer's data in order to deliver information, reports, and insights back to that customer. In that role, they're really a data processor. They're acting on behalf of the customer that's involved. But increasingly, these SaaS and other vendors are beginning to want to use this information for secondary purposes, effectively, and we'll talk about whether or not they are a data controller, something for their own legitimate needs, whether they want to do advertising based on the way their product is used, whether they're involved in direct marketing based on user functionality, or improving the product or services based on the way they see it being used. In all those circumstances, they're gathering data about use or individuals, or maybe engaged in profiling for secondary purposes away from the core purpose that they're providing the service to their customers. And increasingly finding they've got compliance issues as a result of that data use. And for a long time, that data collection has become a challenge. Partly a challenge because the customer's not all that keen that the vendor's using data. They're always suspicious. They don't trust that data use. So they, taking value. Are they starting to compete? Are they using that data in a way which is, non-compliant or not in the interest of their customers' own underlying users? So it becomes quite a commercial debate, but essentially something that the vendor needs to establish and think about, because these secondary uses are becoming incredibly important and increasingly important. And in relation to these secondary uses, you can really, in GDPR terms, say, well, you're either a data controller in relation to that use, in that you're deciding on the purposes of means and processing. You're building an AI model and training algorithms, and that's kind of the likely outcome or the desirable outcome. Or you could be a data processor, acting on the instructions of your customers in order to build these insights and improve the products or build. And on this next slide, we're really kind of looking at these two models, because we're spending quite a lot of time working with our clients saying, well, okay, you're clearly, for your core services, a data processor. However, are you also a data controller? And there are problems with this. I mean, commercially, as I've said, customers aren't that keen on it. But also commercially, if you are a controller using that data to learn, are you using that data against your customers' instructions? You've got, if you're a pure processor, you've got restrictions in the DPA, which say only use the information on, only use the data for my instructions, only, do as I say, don't do as you say, delete the information at the end of the relationships. It's much harder to learn for your own purposes. In fact, in the UK, under the UK's implementation of the GDPR, our Data Protection Act in the UK, use of processing, use of the information for your own purposes as a processor can actually be a crime. So it's tricky. Some models, the vendor is able to show that they're learning on behalf of their customer and remaining a processor acting on instructions. But typically, it turns out when we look at the data use, we look at what's happening with the algorithmic model and how that information is ultimately being used, both for the benefit of the vendor, our own client themselves, because they want to improve the product, and both for the benefit of all customers, in that they're improving a product to sell on to all. It becomes very difficult to justify that as a pure processing role. You're clearly a controller, and if you are a controller, this becomes really quite difficult, because you need to comply with a whole load of other laws as a controller, or a whole load of other obligations, and kind of represented some of this conundrum in the slide here. And I'm really talking about the orange block within this slide, the enterprise SaaS provider. It has a relationship with a customer and a DPA in place, and that customer platform is being used by end users. The enterprise SaaS platform is being used by end users. So as we can see here, they may also be relying on running that whole platform by sitting on top of another host platform or other sub-processors, and you could have a situation where that host or other sub-processors want to learn from data to improve their own services. In this scenario, you're dealing with two types of notice, which makes it tricky. One, the vendor needs to be telling the customer that it's using data. It needs to be carving out a right from the DPA to use data for its own purposes and act outside of instructions from the customer. That can be a friction point in the negotiations. You can't just be acting on instructions, because you're learning with data and you're building your own profiles and your own algorithmic processor. So you need permission from the customer, but you also need a notice flowing down to those end users, the individuals whose data is being collected and impacted. And in many circumstances, you may have a nascent relationship with that end user because they log on to the platform, or they log on to use the tool. But in other circumstances, you might not. The only interaction may be with the customer and their own consumers or their own employees. And then how do you provide the transparency and notice that you're required to? It is very difficult to sort of do that away from the other concerns commercially about reserving IP rights, ensuring confidentiality, making sure there's lawful use, etc. So in practice, some of the AI models we're seeing are really being challenged operationally because individual customers have to account for their data use. And of course, there are many models out there. Not everybody is collecting data indirectly. Many collect data directly and have more control. Others might buy in that data. Paul was talking about sourcing from third parties or from the government. In that situation, if it's still personal data and you're learning from it, you may fight you're indirectly collecting data, and you may face Article 14 obligations under the GDPR. You have to get that notice of use and the purposes of use out to the individuals who are involved in training the data set. So for a lot of reasons, you need to understand the underlying data, and you need to have some kind of program and processes in place. One, to record and document how you're learning. It's no longer okay just to be iterative, ship it out and work out what happens later on. From an EU perspective and from a good practice perspective, you kind of need to be showing why and what you're doing with data and documenting that compliance. And as I said, we'll kind of talk about why you may need a more detailed and a deeper understanding of what you're doing for AI on this subsequent slide. But thinking about things generally, it's all about a level of privacy compliance and then a level of other compliance. Nowhere in the GDPR does it mention AI, but of course you're sucking up data, you're learning from that data, so you're processing personal data. If you're processing personal data, you need to have a lawful basis for that processing. That could be consent. could be hard to get, could be legitimate interest, could be hard to justify. You may be relying on the performance of a contract, but that would have to be a contract with the end user whose data it is, not with a general customer. But as well as having the lawful basis, you've got to have that transparency and notice, and actually be able to getting that transparency down to the individuals who are impacted, because those individuals, one, have a right to know, and two, have, as Paul was alluding, individual data subject rights which they can exercise against you. They may need to pull out their data in an access request, they may want their data deleted, they may want to challenge your legitimate interest determination. So as a data controller, building information from those data sets, you've got to be doing a number of those general core obligations under privacy rules around notice, choice, and fair processing. But you've also got to be thinking about, I'm a controller, is this high risk processing? Are individuals impacted? Do I also need to do a data protection impact assessment, assessing the risks and the measures in place to protect those risks? Am I concerned about international data transfers? What do I have a plan on? What will happen if I have a breach situation? Do I have sufficient security in relation to the information that's being provided? Have I got processes and controls and access controls internally to ensure that that's in place? If I'm sharing data for analysis with a third party, am I using a sub-processor? And have I got to think about flowing down Article 28? And in designing this tool in the first place, am I thinking about privacy by design and privacy by default? Wearing the controller hat and deciding to engage on an AI project is difficult because there's a lot to think about and there's a lot to justify. It's particularly difficult if it's presented to you within the business as something that has happened and you haven't had a chance to influence the way the product and the AI has been developed and its outputs. It's particularly tough to assess. And in a way, there's a bit of a gap in the legislation in that the GDPR talks a lot about informing and giving rights, but it doesn't fully talk about how you make some of these assessments and how you talk and ensure that that processing is entirely fair, accurate, and doesn't discriminate. And maybe, Megan, we can kind of start to talk about the meat about some of this this topic in the rest of this session. So
yeah, we can. I think as Mark mentioned, what does good practice look like? And I think we've covered some of these things already a little bit. But as you mentioned earlier, there are proposals in the pipeline from the European Commission. And if you want to hear a bit more about that, you can head over to our Fieldfisher Tech and Digital podcast, where my colleague Laura Burton and I covered this in a recent podcast. But the important thing to point out, as Mark's also said, is that existing data protection laws continue to apply. So lots of these practices even are going to be familiar, and much of it already aligns with the principles and requirements of the GDPR. So we've talked a bit about training data, and as we mentioned earlier, the quality of data sets is hugely important, and AI systems are only as effective as the data they're fed. So algorithms need to be trained on data that's sufficiently broad and representative enough to cover all the scenarios that the AI is likely to encounter in order to prevent bias and discrimination. And this one is one that comes from the European Commission's proposals. If we look at choice, the more granular choices you can provide for customers and individuals as to whether that data flows into the learning pool, then the better. In production controls and on and off switches are going to be key. We've covered this one a little bit already, but transparency, as well as the information that you're required to provide in privacy notices, companies should think about providing clear and concise information to help individuals understand why AI is being used, how decisions are reached, and how they can be effectively challenged by human review. For example, some such as Microsoft and Google have published their AI principles and commitments already. And the joint, we haven't mentioned this guidance already, but the joint guidance from the UK regulator, the ICO, and the Turing Institute it's called Explain, goes into a bit more detail about this and discusses the processes which organisations should go through to prepare their AI explanations and how that information should be prioritised depending on the user.
Yeah. And Megan, it's worth sort of mentioning on this one, yeah, a lot of transparency is about trust. You know, the reason Microsoft, Google, some of those other big providers have got that is, you know, there's a general inherent suspicion about the autonomy in AI. You've got the Elon Musks of this world talking about machines taking over. People aren't necessarily sure whether they like a computer making decisions for them or not. And you know, if you're in a in the ER, you think you've broken your arm, and the machine's making a decision about whether it's broken or not. You know, one, have you got a right to understand that it's a machine? Have you got a right to human oversight, and or should you at least be told that the machine's made this decision? At the end of the day, if the doctor's tired and been on a 12-hour shift, you might get a better decision from the machine. But there's, it's sort of building up, an understanding of how this autonomy works, and partly distrust by individuals who are experiencing and using AI, partly distrust by those who are the potential regulators of this. They realize the scope for attack, they realize the scope for manipulation, which might have serious consequences for individuals particularly, and also they realize that risks change over time, because a lot of these algorithms are iterative. The AI is learning continuously. It can be on track one day, it can be off the next. We've seen examples of how Twitter bots can be trained to become racist in just a few hours. But they're all examples of where there have been problems for AI, and the big unknown and this new frontier in technology is leading to quite a lot of potential new regulation and potential new guidance. And what we're really beginning to see is, one, we have certain obligations to understand the data inputs and understand the risks and measures and how personal data is being used. But we also are likely to see more obligation in relation to being transparent about AI, being transparent about data handling and data use. And if you're not thinking about that now, and you're not documenting and explaining that and keeping the controls in place, these are all obligations that are becoming, going to become difficult to deal with over time. The problem with a lot of AI is it is that black box. Data goes in, good data or bad data, decisions come out. It's quite complicated to understand how that data comes out and what the what logic is involved and the rest. And I'll talk shortly about some of those kind of logic decisions that you may need to be transparent about. But are you able to justify your compliance, and are you able to explain what you're doing, and really from the outset consider both privacy by design, but also data use by design to justify the fact the data sets used in training and the outcomes are all sufficient and sufficiently protective of underlying individuals, or individuals who are experiencing or using the AI at its end goal. So.
Yeah, and if we think about kind of the internal data handling part of it, outward transparency is super important, but then so are the internal practices to operationalize those principles and ensuring that the business follows them. So probably thinking about how do you train data scientists and analysts and implement policies and controls in a way that can support learning from data. And as Mark said, existing GDPR data handling practices will go a long way, as well as privacy by design programs, existing data use guidelines, things like that.
Yeah, I don't think that data use guidelines is a great example of kind of something which is almost a necessary and internal control. We find sort of a lot of AI is iterative, a lot of machine learning is kind of in its nascent form today, but almost as soon as you've looked at the compliance, as soon as you've begun to roll it out and use it and tested how it can be used and the purposes for which it's used, the internal business teams pop up and say, oh, we've realized we can do this, or marketing would now like to do this, or the support team realize that they can minimize their support requests by understanding patterns in the kind of failings we have. So you're constantly looking at new uses and new purposes, that often bumps up against restrictions around purpose limitation and what individuals have been told in the policies when data was collected in the first place. But it also points to good data handling and processes. And I think we would suggest that, as well as being able to document and understand your risks and how the AI works and be able to explain that, you should also be able to show that you have sufficient internal controls within the business, saying these are the kinds of data you can collect, these are the kind of purposes you can use it for. If you want to have new purposes, we've got a few clients that sort of have a AI committee or an internal analytics committee which review that purpose and look at whether it's justified, consider the ethical angles, then maybe consider how data can be used and accessed and protected internally, and just putting in sufficient controls to educate the individuals who are using these tools or developing them further, really to make sure that they don't sort of morph and get out of your control by increasing scope creep and increasing desires to use and do more. There's the business as usual doesn't stay usual for long. There's always one more thing or one more addition. So kind of an iterative privacy by design and review process is fundamental. And I think we would suggest getting on top of that today is essential, because you're only likely to do more of this, and you're only likely to to be finding more and more of this is happening. So
yeah, and on this topic, I also wanted to add that last year, for example, there was a lot of discussion in relation to voice assistants, and in particular the fact that companies who had deployed voice assistants, they were actually conducting a human review in relation to the information which was collected, and there was a lot of media attention in relation to that, especially because I would say a lot of individuals did not necessarily understand why human review was being conducted, and therefore this led a lot of individuals to just question why it was being done and to imagine the worst. And certainly from an AI training perspective, there is this requirement that in order to properly train the models, well, we have to make sure that that is being properly implemented, and therefore there needs to be some kind of review and oversight being done. But then this was something which was misunderstood, and the reason why it was misunderstood was that there was a lack of communication on this part. There was no indication anywhere in privacy policies or in other disclosure documents that this was being done, and this led to investigations being conducted by certain data protection authorities, like the Hamburg Data Protection Authority in Germany. And following that, a lot of companies temporarily suspended their human review of voice assistants until they could conduct the necessary review of their own internal policies, and they had to update the documentation. And following that as well, the Hamburg Data Protection Authority, they issued guidelines in relation to how human review and voice assistants could be properly performed. And specifically what the Hamburg Data Protection Authority said was that, well, you need consent if you want to record information from voice assistants. You also need consent as the legal basis for review of the recordings, which if those are being done by human beings. And then, of course, there is this requirement to specify in the privacy notice that recording was being done, that certain snippets were being retained for the improvement of the algorithm and the human review. And then they also have to now specify in their privacy policies the fact that that there is a possibility that the record feature of the device may be activated, and that certain conversations may be recorded and analyzed by the company.
Yeah. I mean, great. I mean, some great examples there, Paul. And I think one of the things this points to is, again, why there are suspicions around AI, because AIs go wrong sometimes policy failings or overreach in relation to data use. And this is important. And we're talking about accountability and record keeping a couple of times, but you may be the business that is training your own algorithms and doing your own AI and machine learning. We advise a number of those, but the majority of businesses also are subject to machine learning and algorithmic intelligence in relation to data and services that they're using. So another reason for sort of having record keeping and understanding this is increasingly it would be prudent as a controller or as a customer, I should say, to ask questions of your supplier about what data is being collected, how those data sets are being used, whether or not there is compliance in relation to the data that's being used, because really gone are the days where your service provider is a pure processor. And as I was saying earlier on, there are lots of reasons that vendors want to use data and learn from that data and analyze that data. But really, if you are going to be using those services, exposing your employees, exposing your customers and others to that, you want to verify that they know what they're doing. Do they understand what data is being collected? Are they restricted in certain ways? Have you given them a limited permission? Are they compliant in their own way? If asking simple questions, the vendor can't justify what data is being collected, how it's being used, and how they're compliant. Maybe that data isn't being used in a compliant manner, and maybe there are either additional contractual protections that need to be built in, or maybe you need to be turning some of that data off. And I know Megan, you've got a couple of accounts of what that looks like working for the vendor as well as working for the customer in those kinds of deals.
Yeah, I know we've just got a couple of minutes left. So in terms of whether we think these kind of good practices are there any future requirements to be aware of? I know we've mentioned the EU ones, but is there anything else that we need to be thinking about more broadly in the future?
Well, I mean, I think there are a number of requirements, and I think at the moment a lot of this is going to be around best practice and doing what is right, rather than necessarily new laws which are about to crop up on the books. But there's the AI white paper which really talks about best practices in any event, and it's a long way off becoming law, but I think I would challenge anyone engaged in real AI to say they shouldn't be doing some of this. Because I think it's essential and will become essential. And if you haven't done it today and you haven't thought about it in your processes in the coming years, it's going to be incredibly hard to comply retrospectively when a lot of tools and algorithms have been built and there hasn't been any documentation or justification. There's also the whole kind of ethical challenge of using AI, how it's deployed. But also, is it deployed in a non-discriminatory way, and are you really sure about the outcomes and outputs, and are you verifying that? Sometimes that may be about human intervention, other times that may be about getting the machine to do tests or to retrain and to improve and update the quality of your data sets. You've also got to think about other obligations. We don't come across it all that much, but we have done a lot more in the last 6 months, and that's the right not to have automated decisions taken on you if you're a data subject. That kind of right under the GDPR under Article 22. That's effectively a right not to have profiling or automated decision taken where they have a significant or legal effect in relation to the individual. So it's a narrow, and we don't see many automated decisions which do have significant or legal effects, but we're beginning to, and we're beginning to analyze that. So you need to be looking out for that. One, because there's enhanced transparency. Two, because it builds into the additional right. And three, because also kind of hidden away in a fairly nondescript and confusing manner in that clause, you also then have to explain the logic of that decision making to the users, and that involves another layer of transparency around how you explain that. The explain paper you mentioned from ICO actually is very helpful about some of the ways you could do that explaining, Megan.
Yeah.
But kind of documenting that, having an account of that, and then being careful with your IP and your trade secrets. And we don't really have a lot of good industry practice around that to point to. So we're very much being creative in that area for the products which are getting launched. And it's something which is often forgotten, or something which it's another reason why DPIAs are important, and revisiting that DPIAs, because something you review this month may in 6 months' time be doing a lot more and starting to have a legal and significant effect. So having the right kind of gating and review processes, or these kind of review boards internally, is all about good governance and good understanding of the AI. And I would suggest is actually, for the professionals out there, interesting, and something that helps you get on top of a number of areas. But it's certainly essential, and certainly something which you need to get into in order to justify and legitimize the processing that you're doing, whether it's of personal data or otherwise, to be honest.
Definitely. I think that's some really good takeaways. Thanks very much, Mark and Paul, for joining me today. I think that's it for this session. So if you've got any questions, please feel free to get in touch with Mark, Paul, or me. And as always, the webinar will shortly be available on our YouTube channel, which is Fieldfisher Silicon Valley, and you can also catch up on previous webinars there. And if you're interested in hearing more from us, you can also subscribe to our podcasts. I mentioned one of them earlier, but searching Fieldfisher Silicon Valley, and we've got Fieldfisher Tech and Digital via your usual podcast channel. Thanks very much for tuning in, everyone. Have a good day.